How do you complete a transfer impact assessment? Imagine you're about to send personal data across borders, and you want to make sure it's protected. That's where a transfer impact assessment comes into play. It's like a safety check before moving data outside the European Economic Area. This process is essential for organizations that transfer data using tools like standard contractual clauses or binding corporate rules. A transfer impact assessment helps you see if the destination country's laws and practices keep data safe and if the data importer can follow the rules. It's especially important because some countries may have government agencies that can access data more easily. To start, you need to clearly define what data you're transferring. Think about what kinds of personal information are involved, who the data subjects are, and who is receiving the data. You also need to specify the transfer method you're using. Next, examine the laws and regulations of the destination country. Look into how they handle government access to data, surveillance laws, and how they enforce privacy rights. If the country has an adequacy decision from the European Commission, that means their data protection laws are considered good enough, and you might not need a full assessment. Then, review the safeguards you have in place, like contractual clauses or organizational policies. Ask yourself if these safeguards are enough to protect the data in the foreign country. It's also vital to analyze the risks to the data subjects. Could their data be accessed without permission? Are their rights to access or delete data enforceable in the destination country? If you find gaps or risks, think about adding extra measures. These could include encryption, anonymization, or more detailed contractual clauses to reduce risks. Once you've gathered all this information, document everything thoroughly. Write down your legal analysis, the risks you identified, and the extra steps you plan to take. This documentation is important to show compliance with GDPR rules. Involving the data importer is also key. Talk with them to confirm they can follow the safeguards and understand their responsibilities. It's a good idea to review and update the assessment regularly, especially if laws change or the transfer process evolves. In the world of artificial intelligence and technology law, completing a transfer impact assessment is even more important. AI systems often process large amounts of data across borders, which can raise privacy and security concerns. Ensuring that data transfers for AI training, model outputs, or user data meet GDPR standards helps avoid legal issues and builds trust. Organizations should include TIAs in their data governance plans, especially when working with AI platforms that operate internationally. To sum up, completing a transfer impact assessment involves a step-by-step process of analyzing the legal environment, safeguards, risks, and extra measures. It's about making sure that data transferred outside the EEA stays protected and compliant with GDPR. This process is especially vital in AI and technology fields, where data flows are complex and scrutinized. Properly done, it helps organizations stay on the right side of the law while maintaining the trust of their users.